India Legal, stories that count.
Hello and welcome to another special readout from India Legal magazine. As you know, we are the nation's first political legal independent weekly focusing on controversial issues of national and international importance. The video readouts we present to you regularly are the editorial team's choice of the most significant stories we believe should receive close scrutiny and wide circulation. You can watch them along with the visuals or listen to them as you would a podcast. In this week's readout, we focus on the sensitive and often taboo subject of prostitution. In today's increasingly gender-sensitive vocabulary, we use the term sex work or sex workers. The great philosopher Bertrand Russell called it an institution as old as marriage and possibly even more liberating, if you'd believe that. Here's a famous quote from him. Marriage is for women the commonest mode of livelihood, and the total amount of undesired sex endured by women is probably greater in marriage than in prostitution. Of course, these are controversial words, and Bertrand Russell faced a lot of flack for this position, but it's still one of his most often quoted quotes on the subject. Now, this is the first allusion to marital rape by a modern philosopher. Well, it's food for thought. Over centuries, societies have tackled sex work by dubbing it as sinful or because it spreads disease, and you've heard all the reasons. But leaving morals and sins aside, the fact remains that organized sex work is often controlled by flesh mafias and drug traffickers, and child molesters and prostitutes are often the victims of serial killers and sadists. The question that remains unanswered is, how do we fight the violence, crime, and disease that prey on this profession? Easiest thing, ban it. But will it work, banning it? Well, that's been tried everywhere without success. Or do we take the view that sex workers need protection, legal and physical, moral and humanistic? Now, in this week's readout, I feature the India Legal story done by Supreme Court advocate Saju Jacob Lily Thomas, along with his colleague Tanisha Advani, also an advocate. Jacob and Advani tackle this vexatious subject with sensitivity and originality. They deal with the matter with a focus on the Indian legal system and the court's most recent pronouncements, and we'll go into them. How many people who follow the law are aware that a landmark judgment recognizes that voluntary sex work is not an offense and prohibits police officials from arresting these workers, but allows them to arrest the brothel owner, the one who runs the business? Well, to put it all in perspective, Advocate Jacob observes in his article that the COVID crisis impacted all aspects of human life, particularly the livelihoods of sex workers. The pandemic deprived prostitutes and their kids of food and other daily necessities, and they were eager to return to normalcy like everybody else. Now, in light of these circumstances, the recent judgment in Buddhadev K. Karmasakar versus the state of West Bengal, I hope I pronounced that name correctly, and others, pronounced by the Supreme Court on May 19th, 2022, is significant. It reiterates that voluntary sex workers cannot be deprived of their right to equality, right to work, and right to a dignified life under Articles 14, 19, and 21 of the Constitution. Furthermore, the Immoral Traffic Prevention Act of 1956 criminalizes sexual exploitation, but not voluntary sex work. In 2010, a criminal appeal was filed before the Supreme Court against a sentence given to an accused by the Calcutta High Court for committing a brutal murder in 1999 of a sex worker residing in the red light area. The accused repeatedly bludgeoned the deceased's skull. On February 14, 2011, the Supreme Court categorically dismissed the appeal and upheld the conviction due to the horrific nature of the alleged offence, and thereafter changed it to a PIL, suo motu. This is to address the issue of sex workers nationwide. On July 15, 2011, a bench of Justice Markanday Katju and Justice Gyan Sudha Mishra explicitly declared that their goal was to create awareness in the public that sex workers were not bad people, but were in this profession out of poverty. On February 14, 2011, the bench observed, sex workers are also human beings and nobody has a right to assault or to murder them. A person becomes, they are not objects. A person becomes a prostitute not because she enjoys it, but because of poverty. Society must have sympathy towards the sex workers and must not look down upon them, as they are also entitled to a life of dignity in view of Article 21 of the Constitution, and this is a direct quote, what I just read. In addition, the Supreme Court appointed a panel to recommend how to prevent trafficking and rehabilitate sex workers. According to the panel's final report, fairly comprehensive, submitted in 2016, sex workers struggle to obtain proofs of identity such as ration cards or voter cards as proof of residence. The lack of documents prevented them from opening bank accounts and other facilities offered by various agencies, including rehabilitation programs. Also, district authorities failed to recognize the identities of sex workers and their children. It was recommended that the Immoral Traffic Prevention Act of 1956 be amended. The government informed the court of the appointment of a ministerial committee to look into the suggestions made by the panel in 2020. Currently, there is no legislation that categorically safeguards the rights of sex workers, and there is no mechanism to regulate their working conditions. However, the Apex Court has laid down some guidelines in this recent judgment in accordance with the recommendations of the panel, exercising its powers, that's the court exercising its broad powers under Article 142 of the Constitution, particularly for the rehabilitation of sex workers. Now, these are as follows, and I will enumerate them and go slow because it's worth a listen to. Sex workers are entitled to equal protection of the law. There should not be any discrimination, and the criminal law must equally apply in all cases considering age and consent. Further, when it is consensual sex between the adults, police must abstain from intervening or taking any criminal action. Pertinently, whenever there is any complaint made by any sex worker, the police should take serious and immediate action against it. It's a powerful recommendation. Again, medical aid should be provided to sex workers who are victims of sexual assault without any delay, as per Section 357C of the Code of Criminal Procedure, 1973. Also important, if a raid is conducted on a brothel, only the owners and not the sex workers should be arrested, as sex work is voluntary. This is, remember, this is the court speaking, these are the guidelines. The guidelines further suggest that a survey of all the protective homes must be conducted so that any woman detained or forced into prostitution may be released. Sex workers are also humiliated and disrespected by police officials. They don't treat them with dignity and use abusive language with them just because they are sex workers. The Apex Court stipulates that police officials must treat them with respect so that they can equally enjoy all the basic human rights. Further, the Press Council of India must issue some guidelines for the media so that the identities of sex workers are not revealed at the time of arrests, raids, or rescue operations. Section 354C makes voyeurism a criminal. Voyeurism means, trying to find out what's going on the other side of the curtain, trying to get into somebody else's business through cheap means like hidden cameras or entering places where you're not supposed to enter, or basically violating the privacy, the individual privacy of people. That voyeurism should be made a criminal offence, and so that the identity of sex workers should not be revealed during rescue operations with the client. It should be ensured that health measures, say for example condom usage, shall not be construed as an offence nor seen as evidence of such commission. Additionally, the central and state governments must include sex workers or their representatives in all policy making bodies so that their problems can be resolved. Workshops should be conducted so that sex workers can enforce their rights through the National Legal State Services Authority and District Legal Services Authorities. Also, no child of a sex worker should be separated from its mother on account of her profession. Further, if a minor child is found in the brothel, he should not be assumed to have been kidnapped or trafficked. Any sex worker who claims that it is his or her child must be tested to confirm the claim. Apart from the above guidelines, the Supreme Court also ordered that sex workers be provided with Aadhaar cards based on pro forma certificate to be issued by UIDAI. Furthermore, the Apex Court directed state governments to provide dry ration, access to ration cards and voter card IDs to sex workers. They have a right to vote. On September the 2nd, 2022, the court observed that the centre had still not submitted the draft of the Trafficking in Persons Prevention, Care and Rehabilitation Bill 2022. This is the bill against trafficking, as you will recall. The court again instructed that either the bill be shared within 2 weeks or else the cabinet secretary would be called. And this is the court getting tough and taking this issue really seriously. In upholding the spirit of individual rights, personal liberty and law of equality, the Apex Court has placed constitutional values on a high pedestal as always. As outlined in case Puttaswamy versus the Union of India, the 9-judge bench, famous case as we all know, worth repeating all the time, the 9-judge bench, it unanimously upheld the right to privacy as a fundamental right under the Constitution and gave a broader view of the right to personal liberty protected by Article 21. Buddhadev Karmaskar versus State of West Bengal also indicates that voluntary sex work between consenting adults is private and is a fundamental right and hence protected by the Constitution. Furthermore, in Navtej Singh Johar versus the Union of India case, the Supreme Court unanimously decriminalized Section 377 of the IPC. The combined reading of Article 14, 19 and 21 along with all other judgments proves that voluntary sex work between consulting adults is on an equal footing with any other job or work. Every Indian citizen has the right to practice any profession, engage in any occupation, trade or business subject to reasonable restrictions under Article 19G of the Constitution. There is no denying that it is difficult to distinguish the prostitution industry from voluntary sexual work. There's a thin line here and this is constantly debated. As a general rule, prostitution as an organized business is understood as something that is done. Remember, prostitution as an organized business is viewed as something that is done for financial gain. I repeated that on purpose to drive that point home. As long as it is undertaken voluntarily for the benefit of the person doing the work without commercial assistance from a middleman, broker or third party. This activity is legal and it is lawful. Other forms of prostitution, including running brothels or using commission agents, are criminalized, leading to, supposed to lead to lower human trafficking, kidnapping and abduction. The rates are supposed to have gone down because of these reforms, but the final figures on this are still to come out, but it's at least a step in the right direction. It is permissible under Article 19 to restrict such sexual work in a reasonable manner for the purpose of social controls, societal norms. According to Section 2 brackets F of the Immoral Traffic Prevention Act of 1956, prostitution is defined as sexual exploitation or abuse of persons for commercial gain. Consequently, the Supreme Court has elevated their fundamental rights and freedom to high echelons by this judgment, making society at large aware that they will be treated or shall be treated equally as other professionals. Police and government officials were warned not to compromise their integrity and dignity at any cost. In addition, the Supreme Court ordered the government to submit the draft legislation based on the panel's recommendations. Central governments should establish an effective mechanism that safeguards the rights of sex workers and their families based on the panel's recommendations. No doubt, as Jacob and Advani point out, the judicial pronouncements are complex and subject to self-serving interpretations. That goes with the turf. But the judicial intent seems clear and progressive and in keeping with the views of the British sage Bertrand Russell, who was way ahead of his time in 1928. This is your host editor, Indrajit Badwar. Until next time, goodbye for now.
India Legal, stories that count.